So, Renato, does the latest Supreme Court ruling mean that ICE can just arrest people based on their race?
It's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha and Renato. I teach national security law at Yale University. I'm a former FBI special agent, and I'm the author of the Freedom Academy Substack.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skeet. Wow, Asha, I have to say the reaction to the Supreme Court's opinion in this sort of shadow docket case is very well founded, particularly Justice Kavanaugh's really surprising concurrence.
Well, on the one hand, he's the only one who bothered to offer any explanation at all in this. On the other, his explanation is, I don't know what word I would use to describe it. I'm trying not to say sloppy or intellectually lazy, but just, inadequate, I guess. Do we want to let our listeners know what the posture is? Because this is, again, we're talking about the shadow docket. We're talking about interim orders. I did an Ask Asha video about interim orders, which means that these are essentially the granting of injunctions by lower courts that are going up on appeal by the administration to be stayed. They don't want the injunctions to go into effect. And it's an interim order so that if the injunction is stayed, then basically the government gets to continue doing whatever it's doing until the actual case on the merits gets litigated and reaches what will likely be the Supreme Court, but which could take a long time. It's just, I think it gets so confusing right now because there have been so many of these emergency orders that it's hard, I think, for people often to keep track of, wait, did they just rule on something as though it's a, final ruling? It's not, but it still is bad because it means when they rule in favor of the Trump administration that they can continue to implement their policies even before they fully decide on, whether it is legal or constitutional as a final matter.
Yeah, it's really important. A lot of times people ask me, well, what is the law on this? And then they'll say, how can someone get away with doing this or that? Even though the law says something different. And the reality is that if you're doing something that's unlawful, there's a cost that comes with, and I don't mean costs like dollars and cents, but I mean that there are things that you have to go through in order to prevent somebody from acting in a manner that's unconstitutional or illegal. And part of that is going to a court, getting the court potentially to issue an order stopping that. And if, in this case, if you have done that, for example, if there's a district court judge, a federal trial court judge who's issued a temporary restraining order, and that gets undone by the Supreme Court, that essentially means for months and months, potentially, you're going to have that same activity being undertaken by the Trump administration with no interference whatsoever, even if at some point in the future, the Supreme Court decides that actually, that was unconstitutional all along.
Right. And in order to grant the temporary restraining order, the court looks at 4 factors. So they look at the party's likelihood of success on the merits. They don't decide the issue, but they sort of do a quick take, I guess, on the issue. I don't know how you would characterize it, Renato. They look at the balance of equities. In other words, what the parties kind of have at stake. They look at whether either granting the injunction or denying the injunction, is going to cause irreparable harm to one of the parties, like something that will be they'll be unable to undo if it's finally litigated and it goes the other way. And then there is a public interest factor, though that doesn't often come into play. But so, those are the factors that a court is considering. And then in this case, the district court granted an injunction. The Trump administration appealed it to the Ninth Circuit. The Ninth Circuit upheld the injunction, I think, except for one piece of it where they said it was vaguely worded or something. But kind of the substance of it, they kept in place, meaning that the Trump administration was barred from continuing the activity. We'll describe what the activity is in a second until it got litigated. But again, the Trump administration went running to the Supreme Court, which it has done pretty much since January. And the Supreme Court, as you just explained, Renato, basically undid the injunction. So, yeah,
and that's really significant because in the meantime, if you're somebody who gets detained and rounded up, that essentially means that you don't have any recourse for quite some time. Now, I will note here that the issue, we said that question in the beginning. The issue here, I think, is rather remarkable, and it stems from a specific kind of stop that law enforcement can do. That's often referred to as a Terry stop because that was the name of the Supreme Court case.
Terry versus Ohio.
There you go, very famous case. But essentially, it is about whether an officer can make a stop based on, reasonable suspicion and what the reasonable suspicion would be. And the original idea behind that ruling, the Terry versus Ohio ruling that we were both referring to a minute ago, is that if officers are in danger, they don't always have time to gather their evidence and assess things, determine.
And go run and get a warrant and
or potentially, even if they don't have a warrant, assess, do I have probable cause to believe that Asha has committed a crime? I don't know, but I see she's running away from me and, it looked like she tossed some kind of object. And so or whatever it might be, right? Or whatever, they're like, I see enough here. For example, shots rang out and, I see somebody running. I'm going to, stop that person for my safety or to, ensure that the safety of others or something along those lines. That sort of stop is what we're talking about here, a reasonable suspicion stop. It's not where someone's arrested. You mentioned a warrant. There's no arrest warrant. There's no marshaling of the evidence to determine whether there's an arrest warrant or not. There's probable cause. This is what constitutes a reasonable suspicion. And what mattered here, and the reason this was so important, is because this revolved a reasonable suspicion stop based on essentially someone's ethnic background, a racial background, also based on basically the language that the person spoke. And that enough was part of the question, a big part of the question before the court. Is that alone, the fact that you speak Spanish or the fact that you look Latino, is that enough for law enforcement to stop you?
Yeah, so this is actually a policy or a program that ICE put into effect called Operation at Large. And it essentially instructed ICE agents to conduct one of these stops, if you want to call it a stop, but we can talk a little bit more about what was actually happening on the ground, based on 4 factors. One is race and ethnicity. The second is they're speaking Spanish. The third is their presence at a particular location, like at a Home Depot or at a 7-Eleven. And then the fourth was if they're engaged in a particular kind of job, typically like a manual labor job. And that, it sounds like any one of these or any combination of these was sufficient for them to essentially detain somebody. And, the case that you're talking about, Renato, part of what it's saying is that the Fourth Amendment is triggered even when you stop someone briefly. Like that is a seizure within the meaning of the Fourth Amendment, and it goes into what the government needs to show. And as you mentioned, the standard for that is a reasonable suspicion. And I think it's important to kind of just highlight the different burden of proof standards. Like reasonable suspicion is less than probable cause, which is less than like probable cause is what you need for a search warrant or to arrest someone, to issue an indictment. And then, of course, when you go to trial, you have a higher burden of proof, which is the proof beyond a reasonable doubt. So that's kind of the latter. And I mention that only because that's something that becomes relevant into what Kavanaugh says in order to justify, his view of this. But the lower court basically said what she enjoined the government from doing was relying solely on any one or any combination of those four factors alone in order to detain, stop somebody. She said, if there's something else you have on top of that, which gives specific articulable facts that lead to a reasonable suspicion that that person is there illegally, that's okay. You just can't rely on, any one or combinations of these four factors alone. That's what she was saying.
Right. And what I think is important to note there is that essentially what this is doing is her ruling, Judge Frimpong's ruling, my former classmate from law school, was essentially basically saying you have to see something or do something that is like a plus factor on top of, let's say in this hypothetical, the fact that someone speaks Spanish or their ethnic background or something along those lines.
They're speaking Spanish at a Home Depot.
Right.
Basically, that's, yeah.
Yeah. So essentially, there's got to be something there. Someone told you something, you saw something that was in addition to that. And why does this matter? And why is this a seizure in front of for the Fourth Amendment purposes? Well, stopping somebody, we use this term stop, and law enforcement uses the term stop. What stop means is that you're not free to go. It means that you can't go and go to the Home Depot hot dog stand and get a hot dog. You can't drive home with your kids. It means essentially you're arrested. And it's not the way we usually think of arrest. The way we usually think of the word arrest is somebody puts handcuffs on you and takes you to the police station and books you. But actually, for Fourth Amendment purposes, that is an arrest of sorts. You are being stopped for, or at least you are not free to leave for that period of time. And so that the stakes here are significant. And the significance for a group of people is, can I go buy lumber at Home Depot or gardening tools at Home Depot without being stopped by law enforcement, by immigration enforcement, solely because of my national origin or the language that I speak?
Right. And this case had been brought by individuals who had been stopped under Operation at Large, including U.S. citizens who had been, stopped based on this criteria, as well as several organizations that are representing people who, fall into this category. And so where do you want to start? Because I know that you took a lot of notes on Justice Sotomayor's dissent. She was the only other person in this that actually offers some commentary, because, one of the things that's been happening with these shadow docket rulings is that they'll basically just, overturn a lower court injunction, but without saying why. And then lower courts are left to try to figure out what they're supposed to do when the same situation happens, in other areas. And we've seen Justice Gorsuch and Kavanaugh then we haven't even addressed this on this podcast, but, you basically suggest that lower courts are acting, defiantly or whatever. But anyway, in this case, it's interesting because we do have this concurrence by Judge Kavanaugh where he tries to justify what's going on. And then we have this dissent by Sotomayor.
Yeah. And I guess, but I would also just want to mention, is that before we even get there, this how important it is that this is a decision that I think is pretty far-reaching and is at odds with, ironically, the thrust of where the Supreme Court has gone up till now in recent years, where they've been so focused on not paying any attention to someone's race or gender in a lot of other contexts.
Oh yeah,
right. And instead of getting an opinion, because one thing you've mentioned a number of times, Asha, correctly, is that the majority has not actually written an opinion at all, and really that's what we've come to expect from Supreme Court decisions. That's how it's supposed to work. The Supreme Court is supposed to set forth its reasoning, and that reasoning is what binds lower courts. They will look at that, and they will look at the holding of the court and understand the scope of what this means. The concern here is not, yes, we have this opinion by Kavanaugh, which we've discussed to some extent. Kavanaugh's one vote. And his opinion is not really binding on anyone. It sets no limits on anyone. And you would think you'd have a majority opinion that would set limits to some extent on what the government can do here and prevent, potentially even more egregious actions being taken by immigration officials. And we don't get anything like that.
Yeah. So let's talk about what Kavanaugh says, and then we can turn to what Sotomayor says. So Kavanaugh basically he's addressing two arguments that that are made by the government, and one of them I find incredibly problematic. So the first is there's a standing argument. So standing is basically the right of somebody to be able to sue, that they actually have suffered some kind of injury that they can seek redress for. So it's sort of a procedural thing. And there is case law, a case called City of Los Angeles versus Lyons, where someone who had been subjected to a chokehold by the LA police sought an injunction against the police department doing future chokeholds. And basically the court said, no, you don't have standing to ask for that injunction, because even though you suffered a chokehold in the past, without showing that this is some official policy of the LA police department, there's no basis for you to believe that you will be subject to a chokehold again. Something, it was like too speculative or it was a predictive harm or something like that. What Kavanaugh says is he relies on this case to basically make the same analogy to the plaintiffs here, where he says, yes, some of these people got stopped, but there's no basis to believe that they themselves specifically will get stopped again. And it's just a very weird argument, because this analogy was rejected by the lower court, who said the reason that this is different from Lyons is that here you actually have an officially sanctioned, pattern of conduct. Like it's got a name. Operation at large. Like there's 4 criteria that people are being instructed to stop people on. So, and in fact, some of these, at least one of these plaintiffs, I think, was stopped twice. So they are definitely in the universe of people that would be subject to this. But Kavanaugh basically rejects that, and I think that this portends that when this does come back up again on the merits, that they might try to just get rid of it on those grounds. And you can imagine the implications of that, Renato, that if you are trying to stop the government from engaging in conduct based on something they're doing, but the court can't do it because it's going to be in the future, I don't even know how you would stop them from doing anything.
Yeah, there's this real focus, and Justice Sotomayor talked about as well, about this sort of real and imminent threat is what, that you essentially, basically, unless you are being essentially the argument is that unless you are, the government is outside your door, you don't have standing to sue, based on a potential constitutional violation. And which means that essentially you have no possibility of actually getting relief at all, like as a practical matter, right? And so ultimately what's going to end up happening is, and that's kind of what, by the way, if we were back in non-shadow docket land, if we were back in like actually right opinion land, you could imagine if that was where this opinion was, it would be, it's something we've seen before where the Supreme Court essentially denies someone a meaningful opportunity at relief, and the dissent makes issue at that. But, here, we don't even know, by the way, where those other votes are. I think it's a good suspicion about where those votes are. We don't even know it.
Yeah, it was just odd that was something that Kavanaugh chose to mention, because he was mentioning it on the likelihood of success prong, which to me, I was like, that is really crazy. And not for nothing, but we have seen other cases where speculative harm has not stopped them from ruling on a case. There was that, the wedding cake web designer person. That was all about, well, if I were to create a website, this would, impinge on my free speech. And so there was all this future looking harm that they're fine with in some contexts. And, it's sounding like in this kind of context, when it's actually, dealing with Fourth Amendment protections, they're not, or at least Kavanaugh is not so, concerned about it. But then he goes to the second argument, which is the merits argument about those 4 criteria and whether it's enough to form reasonable suspicion. And he's like, yeah, common sense would tell you that statistically, these people could be illegal and it's totally fine. And he cites this statistic that, about 2 million people in LA are there illegally, and he doesn't offer a citation for it. It turns out that that's come from the government's brief. I guess their own internal statistics, unclear where it came from. And he basically says, that's fine. Maybe you can't rely on race and ethnicity alone. He concedes that. Like, you can't stop someone just because they're Latino. But if they're Latino and speaking Spanish, or Latino and at a Home Depot, or Latino and, working on a roof, I guess, then that is fine. That, it would otherwise thwart the government's efforts to combat illegal immigration to make them go beyond that. And Justice Sotomayor is very shocked about this.
That's right. And I think one of her lines that I thought was, it hits the nail right in the head, is she talks about those factors, quote, describing a very large category of presumably innocent people, right? It is, it is astounding, right? That the fact that you, let's say, are in construction, or that you work at Home Depot, or go to shop at Home Depot, which I do as well, for what it's worth, from time to time, shop at Home Depot, or you speak Spanish, those sorts of factors can lead to you being stopped by immigration officials. But essentially, one of the thrusts just underlying her dissent, which I thought was so important, was she really, in my mind, calls out the majority here for treating people as parts of a group and not as individuals. And I thought
it's stereotyping.
Yeah. Well, and it's so contrary. That's what I'm saying. It's so contrary to the thrust of some of the Supreme Court's recent jurisprudence. Like, if you look at, for example, in the DEI and racial preferences jurisprudence that they've had recently, or the overturn, like you look at the Harvard case versus citizen protection.
I'm going to write about the Harvard case I'm going to write about this comparison for my Substack this week.
Okay. Well, you and I are thinking alike.
Yeah.
Not surprising, which is that they're talking about the importance of treating everyone as an individual.
As an individual. Yeah.
Right. You're not Asian. You are Asha, you are not, or whatever. Right. And, okay. So if you take that seriously, than treating somebody who happens to be Latino or happens to speak Spanish or happens to work at a construction site or whatever. Treating that, you're not treating them as an individual. And one of her points is that she says, here's another quote I thought was helpful, important. Aggregate statistics cannot substitute for the individualized suspicion that the Fourth Amendment requires. I think from her perspective, what her point is that the Fourth Amendment is supposed to be about law enforcement knowing something about you,
Right.
not, Asian people generally, not South Asian people generally, but you, Asha. And that's when somebody makes a stop, it's because they see something about you specifically that you did, not just boiling you down to a statistic, boiling you down to a racial classification. And that racial classification or other classification, you happen to be a Home Depot shopper, maybe not a protected class in the Constitution, but nonetheless categorizing you as part of a group. That is so contrary to what the Constitution requires.
For sure. And they point that out, as you mentioned, in these other cases, including the affirmative action case, where they talk about, the harmful effect of kind of big generalizations about racial groups. But here, I just want to also point out that Justice Kavanaugh's 2 million statistic, which again, I don't know if that's correct or not. But there are approximately 10 million people who are Latino and speak Spanish in this geographic area. And they make up almost 40%, or I think 47.3%. I was reading Steve Vladek's post about this. So almost half the population. So it's, even as a group, it's overbroad. In other words, it by definition includes a category of people, if you just look at the race and ethnicity and the language speaking, which according to Kavanaugh would be enough, by the way, to stop someone. Even by his own statistic, about 80% of those people are not the people that ICE is looking for. So you have, even if you're using statistics, a high probability that you are going to erroneously detain somebody that is actually not in the country legally. And I mean, there's actually in the lower court testimonials about people who encountered exactly that situation.
Yeah, it's interesting, by the way. This really feeds into another piece of the puzzle here, irreparable harm, right? Which is part of the standard that, of course, district court had to consider. Here, and that was discussed at length in Justice Sotomayor's dissent. Really, if you actually look at where the harm could be here, I mean, there's a focus, that Kavanaugh, of course, is concerned about the administration being able to enforce the immigration laws. And, the numbers that you cite kind of, and as I think the justice points out, they really underlie how much people can be suffering true harm from the government's actions, because you're talking about millions and millions of people who could be detained, for example, who could have their lives, their jobs disrupted by government activity. If you are a judge just looking at kind of who's more likely to suffer harm here or what sort of harm you need to be concerned about, I think most judges would be concerned about the people who are innocent and are being stopped for no good reason.
Not Justice Kavanaugh. So in addition to his sloppy math, because he doesn't cite the denominator of the population that he thinks, warrants this kind of racial generalizations, he minimizes the harm on the people who are stopped, because what he says is these are just brief stops. And really all that's going to happen is that ICE is going to ask them if they're here legally and just, if they're Americans. And if they say yes, then ICE will promptly let them go. And this is one of the things that Justice Sotomayor loses her mind about, because she says that is just belied by the record from the district court, because you have these sworn affidavits from people who were not detained briefly. They were detained for, 20 minutes, 30 minutes. They were detained even after they showed actual government real ID. So what, even the way that he's trying to minimize the harm, which again is sort of, in my Substack, I teach about moral disengagement strategies. It's a way to kind of get an off ramp for like the harmful effects of what you're doing. But he's just basically saying, no, it's not that bad for the people being stopped. And this is important in terms of the shadow docket generally when it comes to these injunctions against the Trump administration. This court has taken the position that the government suffers irreparable harm whenever it is unable to implement its policies, by definition. Mm-hmm. In other words, the executive branch, whenever it is unable to enforce the laws, suffers de facto, ipso facto, irreparable harm. And so that is weighed against, what's a few people being thrown on the ground here and there. I mean, he doesn't acknowledge that that's happening, but like, that's really the calculus that he's making. And it's interesting to me that he actually does have to distort the consequences of what is really happening to make his case on that balancing.
Yeah, Asha, one of the crazy things about that is enforcing the law kind of presupposes the question of what the law is. In other words, if you're doing something that is not lawful, if you're violating the Constitution, you're not enforcing the laws, you're committing a violation.
Right.
And on the flip side of it, you talk about what it's like for somebody to be stopped. One thing I'll just say from personal experience is that when I was a federal prosecutor, I didn't think about, but I understood when I would send an FBI agent out to interview someone or send out a subpoena, I think I didn't fully appreciate the extent to which that upends someone's life. Mm-hmm. And I understood it in an intellectual level, but I didn't understand it in the way that I do now after many years of representing people whose lives are turned upside down because they received a subpoena or because they just got an interview, a request from an FBI agent, and how terrifying that experience was for them. I can't imagine if you're somebody who's just going to, buy some tools at Home Depot, to being stopped by an ICE agent has got to be a terrifying experience, no matter who you are, no matter what your background is. And so the idea that that's harmless or that's not an important harm is really mistaken.
Well, ask Kilmar Abrego Garcia, who got picked up at a Home Depot because he was wearing a Chicago Bulls hoodie, remember? Which made him a terrorist. Well, and it's also, Renato, I think there's two things here. First, we've had a guest on before, Rachel Barkow, who pointed out that most, if not all, of these conservative justices had their only government experience before coming on the court was in the executive branch. And so they just all are super pro executive power. So this, and I think they just think that there's very little that is illegal for the government to do, kind of with this unitary executive, Nixonian view that if the president does it, it's legal, except when it's a Democrat president. Because one of the things that Steve Vladeck points out in his write-up about this week is that, Kavanaugh references, well, we've done this before, and he references two cases. But they didn't do it before under the Biden administration, because under the Biden administration, they kept the injunctions in place that stopped the Biden administration from implementing their policy until it was litigated to the final conclusion, which was like years later. In other words, they don't seem to find that it harms the government irreparably if they're preventing a Democratic president from implementing their policies. And it's like, it's kind of like now just so obvious. It's very frustrating. And the other thing, and I'm interested to get your take on this, is this real crazy statement that Kavanaugh makes where he says, ultimately, for the people being stopped, their interest is in evading the law. And that's just not a good enough interest to override the government's interest in enforcing the law. And I was like, this is so dumb on so many levels. Like, I don't know where to start. Because you can say that literally about any due process protection. You could frame it that way. Like, hey, this person has an interest in a fair trial because they have an interest in evading the law. Like, then we should abolish it. Or, any hurdle that we put on the government is, by definition, going to potentially help some subset of people who may actually have committed a crime, right? And we understand this in putting those due process protections in place. Like, what's the Blackstone quote? It's better that 10 guilty persons escape than one innocent suffer. Like, we acknowledge that could be the case, but we also, that's the trade-off we're willing to make in order to live in a free society, understanding that the government has much greater power than any individual citizen. And this is the only way that you keep a check on them. So I'm sorry, I thought that was a really dumb thing to say.
Well, I would just say, it maybe is why the majority didn't write anything at all. Okay. In other words, I think there are I think it's hard to justify the majority position in this unless you're relying on something like standing, okay, or something like that, where you can sort of say, well, you can kind of rely on sort of general principles and sort of not get in the weeds of what happened in the record below. When I was a clerk and when you were a clerk, or you were clerking around the same time, there's this whole phrase called, if, does it right, or is it, does a certain position right? Like, in other words, can you justify that position in writing an opinion? And I think, here, I think one could argue whether or not you could possibly write a majority opinion that justifies this. The reasonable minds might disagree on that. But I think, Kavanaugh says, maybe pun intended, hold my beer. And, part of what he was doing here was writing something that I think is not as careful and as thoughtful as it could have been if you wanted to navigate all the problems here and try to reach that result. And I think, that might be why he was writing on his own for this one.
Well, I think the upshot is that he is basically sanctioned an idea that an entire class of people can be second-class citizens based on their race. That people who have literally done nothing wrong now have to fear in a way that other people of other races don't. That they could get stopped simply because of the color of their skin or the language they're speaking or where they're shopping or what they do for a job. And as you mentioned at the very beginning of this podcast, that is just fundamentally abhorrent to our Constitution. But it is going in this direction that can be very, very dangerous, which is kind of enshrining as a legal principle that there are just some people that are, have a greater propensity, that are statistically just going to be more likely to be criminals. And, and we can determine that based on race or language. And you can see where that could go and how dangerous it is. And frankly, I think that this is a result of Kavanaugh maybe just watching too much Fox News. I mean, he seems pretty convinced of himself.
Well, I would say, speaking to a group that's convinced, I mean, it's interesting because, Trump did receive a higher percentage of Latino vote than he had in the prior election. And, one of the things that you and I have, bemoaned in the past is the fact that you have kind of an disinformation world where, facts get twisted. And it's interesting, do people who voted for Donald Trump, who are part of what, as you're suggesting, treated as second-class citizens, will they become aware of what happened here? will they understand that Trump's responsible, ultimately responsible for that or not?
Well, maybe if they listen to our podcast.
Indeed.
So, Renato, speaking of Supreme Court, it looks like the Supreme Court will be deciding the issue of whether Trump's tariffs are legal.
That's right. This is stemming from a case that was challenging Trump's authority to impose, I think, a certain subset of the tariffs that he's.
It's a subset of the tariffs, yeah.
And these were, I believe, there was certain tariffs that he imposed that were in response to a declared supposed national emergency regarding trade deficits. So the fact that we have trade deficits, which we've had under any president in our lifetimes, and beyond that, that's now an emergency. And so that required, all sorts of worldwide, retaliatory tariffs against all the countries. And the other set of tariffs were tariffs that he imposed to pressure like Canada, Mexico, China, relating to drug trafficking, human trafficking, and so on. And that was also a sort of an emergency effort that Trump was undertaking.
Yeah, and so this whole subset of tariffs, which I think are encompassed by 5 executive orders, were all issued under the International Emergency Economic Powers Act. And I didn't ask Asha about this. And basically, there's a number of statutes that authorize Trump or authorize the president to impose tariffs in certain situations. All of them have either some limit on the duration, or they have some limit on the amount, or they require factual findings. IEEPA doesn't have any of those requirements. It only requires that there be a persistent and extraordinary threat that the president declares, and then it gives him discretion to engage, to quote unquote regulate imports, but it does not mention tariffs. And so this is sort of what it turns on. The question is, when Congress passed IEEPA, did Congress intend to give the president the power to just basically create a new tariff schedule, which otherwise is really that is an Article 1 power. That is a congressional power. So, does the statute authorize it? And if the statute does authorize it, is it somehow an unconstitutional delegation? Because it's basically allowing him to more or less exercise Congress's authority. And so the lower court, or the Court of Appeals, said that IEEPA doesn't give the president this authority. And it looked at the precedents before that Nixon tried to do this with a previous legislation, and IEEPA was passed in response in order to rein in presidential authority. And it also said that regulate imports doesn't include tariffs because there's all these other statutes that actually mention tariffs. And so this kind of supports this. This is sort of statutory construction, like when you're trying to figure out Congress's intent. And then they also invoked the major questions doctrine, which we can talk about as well.
Yeah, I think, one thing that's interesting here is that this was a victory against Trump in the federal circuit and before that in the Court of International Trade. And it really, in my mind, it shows a little bit of a difference between how we just talked about a prior decision in which you had a disadvantaged group, right? A group that's being targeted by the president, who've been targeted and are trying to litigate for their rights. Here you've got, most of American business, which has hired a top Supreme
conservative
Court
group.
Advocate. Right. Yeah. And who've got top Supreme Court advocates, there's libertarians, conservatives, and liberals all coming together opposing Trump. And you notice you get a different result here. And I predict a different result in the Supreme Court potentially as well.
Really? I don't know.
So.
I'm not
That's
sure.
Interesting.
I'm not sure. And I think, there will be this like statutory construction piece that they might say, hey, regulating imports does include tariffs. And this is what regulate means. It will be interesting to see where they come if they talk about the major questions doctrine. And here's why. Because the major questions doctrine is what the Supreme Court based its opinion overruling Biden's loan forgiveness program. Okay? Biden's loan forgiveness program was an executive order which relied on two statutes, the HEROES Act and something else, which basically authorized it's sort of similar, like authorize the Secretary of Education to modify or waive, loan terms in response to a national emergency. And this was all done in response to COVID, right? What the court said is, modify and waive does not include canceling loans, writ large. That involves so much money. And it's such I forget the phrase they use, but it has such a huge impact, economic impact, that's essentially an entirely new regulatory scheme. In other words, it's like a new legislation. And so, the president can't use a delegated authority to effectively create like a whole new paradigm that would otherwise be something within Congress's power. Like, in other words, he overstepped his executive branch authority. Wow, they don't seem to do that anymore. But anyway, in doing this, and what the litigants here are arguing is that this is also implicates the major questions doctrine, because if Trump can suddenly create a global trade war and be shifting tariffs and doing it against all kinds of countries all the time, it has a major economic impact and is basically an entirely new regulatory scheme.
Yeah, and that is really what he's trying to do. I mean, let's just, call a spade here. Trump is using this quote unquote emergency power to essentially enact tariffs against everyone around the world and try to quote unquote cut deals and so forth with every country on earth, and spark, as you pointed out, a trade war. I will say this may work. You may be right about the Supreme Court. I don't know. If the Supreme Court sides with Trump on this one, there's going to be a big fight, and it's actually going to hurt Trump and MAGA in the long run, because there's so much money and power that is going to be on the other side of this one, that there's going to be new legislation or some other activity that's ultimately going to curtail his power going forward.
But he's going to grant exceptions for the people who come and kiss the ring. That's what he's doing. Tim Cook came and gave him a bar of gold or whatever and was like, you are the best president in the whole world. And got to, I guess got exempt from whatever tariff was going to impact Apple products. So this is the thing. It's an extortion scheme.
Okay. By the way, you undersold that. That was not a bar of gold. That was a gold iPhone. Get it right.
Okay. Anyway, my point is that I think, the consequences, I think, can be mitigated through corrupt means, is my point. But yes, it will be really interesting, because this will ultimately, though, no matter what kind of exemptions he does, it hurts the bottom line of ordinary people.
It does.
That, I think, is the more important piece of it.
It does. I agree. Oh, it's the more important piece. It's just whether, most people are getting misled and deceived by Donald Trump. And so, whereas businesses, I was assuming, may not, but you're right, they may all cut their own side deals. But you have to think there's a lot of businesses that don't have that access or don't cut their deals, or whatever.
Small businesses are going to be really harmed by this.
Yeah. And you could, over time, that could have an impact and could potentially curtail his power. What I'm interested in are the times, where is Trump going to overreach? Where is that going to limit his power? Where can there be changes in kind of, where can there be checks on him? And this is one area where he might eventually get checked.
We'll see.
So, Asha, before we go, my wife and I have been trying to figure out our plans for December. We always take a family vacation in December, so we are looking at our options.
What are you looking at?
So last year we had a really chill vacation where we were in the Caribbean. My wife wants to go back to Europe this time around. And so we're looking at river cruises and maybe a river cruise of the Danube, which we've never done that part of Europe, Eastern Europe, which would be really cool.
So interestingly, I will be in Germany in December.
Whoa.
Yeah. And then from there, I fly to Thailand.
Oh my goodness. Okay. I thought for one moment I would do something for like 1 week or two of my life that would be more fabulous than you, Asha. And you've managed to outdo me. I'm amazed. I'm impressed.
Thank you. Thank you. No, I'm going out to Germany, to Munich to give a talk for the Yale, one of the Yale groups there, and some other groups. I'm going to give a talk, and then I have a CIA friend in Thailand, and I'm flying out there, and we're going to go to, I think, to Phuket and somewhere else. I don't know. We have a whole planning call coming up on Sunday night, and we're going to figure it all out.
Wow.
And I'll be there for almost 2 weeks.
Well, the CIA will not be accompanying me on my trip, so a little
Maybe I shouldn't have said that on my podcast, because now I'm going to have like intelligence services like following me around on,
if
in Thailand.
If this episode is deleted, or if anything happens to our podcast platform, you know why, and you can blame the right person.
Asha. Yes. Wait, who are we talking about? Are we talking about Tulsi Gabbard? Are we talking about...
I think that's a great place to leave it for this week.
Fair enough.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.